Now it's time for the last word with Lawrence O'Donnell. Good evening on this big news night, Lawrence.
Good evening, Alex. And of course, we have our Supreme Court experts with us, Neil Katyal and Harvard Law professor Lawrence Tribe. They've got a lot to say, and I'm going to get straight to it.
Do it.
Thank you, Alex.
Watching.
Thank you. Well, lost in the fog of today's Supreme Court news is the hard fact that Donald Trump is still scheduled to go to trial in Manhattan on March 25th. To face criminal charges in his first criminal trial, charges that he tried to affect the results of the 2016 presidential election by making hush money payments to porn star Stormy Daniels, who will likely become one of the star witnesses against Donald Trump in that trial, a witness who even Donald Trump's followers will have no problem understanding when she describes what Donald Trump did with her alone in a hotel room while his wife was pregnant, and when she describes how Donald Trump delivered his hush money payments to her. And nothing that the Supreme Court did today is helping Donald Trump get out of the crushing weight of $500 million of civil judgments that he is now facing in New York. Today, Donald Trump said he is not rich enough to pay those judgments after previously testifying under oath that he is rich enough to pay those judgments. We will get to the struggles criminal defendant and civil defendant Donald Trump is facing in New York later in this hour. Today, at least 4 members of the United States Supreme Court agreed to hear Donald Trump's appeal, arguing that presidential immunity protects him from criminal prosecution for the charges filed by Jack Smith against Donald Trump for crimes leading up to and on January 6th. It takes only 4 members of the court to agree to hear a case, and of course, it takes a majority of 5 members of the court to issue an opinion in the case. The Supreme Court threw out half of Donald Trump's appeal today and granted a hearing on the other half of the appeal. The part of the appeal that the Supreme Court threw out today was Donald Trump's claim of double jeopardy on the basis that he is now being prosecuted for some of the same crimes he was charged with in his second impeachment trial in the United States Senate, in which a majority of senators voted to find him guilty, but not the 2/3 necessary to convict him. The Supreme Court gave Trump's lawyers 3 weeks to submit their brief and gave Jack Smith then 3 weeks to reply to the Trump brief. Then the Trump lawyers will get a final week for a final written reply. And a week after that, the Supreme Court will hear the arguments in the case on April 22nd. The Supreme Court is not being asked to provide total and absolute immunity for any and all possible criminal conduct by a president. The Trump petition to the Supreme Court only asks for immunity for a president's official acts or, quote, those performed within the outer perimeter of his official responsibility. The argument Trump's lawyers make before the Supreme Court could be a rerun of some of what we heard in the appeals court.
Could a president order SEAL Team 6 to assassinate a political rival? That's an official act in order to SEAL Team 6?
He would have to be and would speedily be impeached and convicted before the criminal prosecution.
What if he weren't? There would be no criminal prosecution, no criminal liability for that?
Chief Justice's opinion in Marbury against Madison and our constitutional tradition and the plain language of the impeachment judgment clause all clearly presuppose that what the founders were concerned about was not.
I asked you a yes or no question. Could a president who ordered SEAL Team 6 to assassinate a political rival who was not impeached, would he be subject to criminal prosecution?
If he were impeached and convicted first. And
so your answer is no.
My answer is qualified yes.
Jack Smith won a procedural point with the Supreme Court today. Donald Trump's lawyers were not actually asking for the Supreme Court to hear the case now. The Trump lawyers were asking for the Supreme Court to send the case back to the Circuit Court of Appeals for another hearing there before the full 11 judges of the Circuit Court of Appeals. In Jack Smith's brief to the Supreme Court, Jack Smith argued that there was no need for the Supreme Court to hear the case at all. But if the Supreme Court was inclined to hear the case, Jack Smith asked the Supreme Court to not send the case back for another round at the appeals court, but to set an expedited hearing at the Supreme Court, schedule that expedited hearing, and that is what the Supreme Court has now done. Leading off our discussion tonight is Neal Katyal, former acting U.S. Solicitor General and host of the podcast Courtside with Neal Katyal. He is an MSNBC legal analyst. And Neal, I want to begin the way all lawyers begin when they get these notices from the Supreme Court that they're going to hear your case. The Supreme Court identified for the lawyers on both sides the question and the only question they want to hear addressed. And I'm going to give that question to the audience now. The question is whether, and if so, to what extent, does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office? How would you address that question?
Well, if I'm Jack Smith, the prosecutor here, I would say absolutely not, or maybe heck no, and just point to the proud tradition of our Constitution, which is at its essence, Lawrence, there's one central idea, which is no person is above the law. And what Donald Trump has done throughout his presidency, before and after, is always basically his arguments amount to, I'm above the law. So when he was president and there was the Mueller report, which outlined 10 crimes he had committed, he said, you can't indict me because I'm a sitting president. He then gets voted out of office, and then he commits crimes on January 6th to try and stay in office. And he says, you can't prosecute me because I'm still a sitting president. So then Congress goes and tries to impeach him for this, and his lawyers go to the Senate and say, oh, no, you can't impeach him. You can only prosecute him after he leaves office. So then Jack Smith does exactly that. They prosecute him after he leaves office, and he says, oh, no, you can't prosecute me because I was impeached before and I wasn't convicted, so now I can't be prosecuted. It's all just a big shell game. It always adds up to the same thing. Donald Trump evades the law. And unfortunately today, Lawrence, the Supreme Court put its thumb on the side of saying, Donald Trump, we're going to help you evade the law. There's lots of caveats there that we can talk about in a moment. But, you know, that is, I think, the upshot of where we are today.
And do you mean evade the law simply by the delay in the trial, or are you anticipating, based on what you're seeing in this order today, that this court, 5 justices on this court, could actually find some immunity provisions to apply to this case?
I cannot imagine 5 justices, Lawrence, of the Supreme Court saying that Donald Trump has anything like a serious legal claim here. It is so antithetical to everything we as lawyers, we as citizens think about our government. And the clip you just showed before illustrates the consequences. A president can go and assassinate his political rival and say it's an official act and you can't prosecute him. That's, I mean, Looney Tunes, to put it mildly. So no, I don't think that's the worry. The worry is the Supreme Court agreed to hear this case and set a fairly slow schedule of hearing it on April 22nd. I know Trump wanted a longer schedule, but still, that's a long time. And for reasons we can talk about, when you start doing the math, there's a real risk that Donald Trump could evade justice and evade this prosecution. It
seems, according to the question that the Supreme Court is asking, that this could be a narrower argument in front of the Supreme Court. Apparently there will be nothing about double jeopardy. They seem to, because those are the 2 questions that the Trump lawyers brought to the Supreme Court, the double jeopardy and this immunity for official acts, or, as the Trump lawyers put it, acts that are at the outer perimeter of official duties. It seems that discussion about the perimeter and what is an official act will be the focus of this argument.
That's exactly right. Donald Trump's lawyers had made another argument about double jeopardy, which was even more bogus than their absolute immunity one. And that is really saying something. I mean, you got to try to come up with an argument that's weaker than the absolute immunity one. But Donald Trump's lawyers managed to find it. And the Supreme Court didn't bother wanting to hear that piece of it. You're absolutely right. So it does turn on this absolute immunity thing. And the way that the court has written it, they've written it in such a way, it says alleged official acts. And by the alleged official acts, they don't mean what the prosecutor is alleging. They mean what Donald Trump, a former president, is alleging. And the idea that someone can just stand up and say, well, because I was a former president, I'm alleging these are official acts, like trying to launch a coup on January 6th. That's an official act. And now you have to evaluate my immunity claim. That can't possibly, Lawrence, be what the law is. So I'm not worried about the Supreme Court ultimately doing the right thing when they hear this case. I'm worried about how long it's going to take for the Supreme Court to do the right thing and whether the American public is going to be deprived in the interim of actually Donald Trump ever reaching justice. And there's one other point I'd make about this, which has to do with prosecutorial norms, because there is an informational asymmetry here. During this whole delay period, while the Supreme Court hears Trump's case, Trump can go out to the cameras and say the case is bogus and attack Jack Smith and all sorts of stuff. Federal prosecutors don't act that way. They only get to speak through their filings and their presentation of evidence. So now with these months and months of delay, that's great for Trump. He's going to get to claim he's being persecuted without the public ever having the opportunity to actually hear the very persuasive evidence against him or a jury to hear those things.
Neil, I'm wondering why it took the time it took for the Supreme Court to issue this one-sentence question, which is what the argument's going to be about. So what I'm wondering about is, as you know the court and as you see what they issued today, is it possible that they were struggling to get to 4, that there were 3 and they were working on getting a 4th and it took them a while to get to a 4th? Or is it possible that there may be well more than 4, including people who have different incentives for this, including possible, justices appointed by Democratic presidents who think, something this big, the Supreme Court should have, the last word on it. And then how long would it take a group of Supreme Court justices to negotiate the exact wording of that question they issued to the lawyers today?
Lawrence, I'm totally baffled by why it took this long. The Supreme Court can act more quickly. It did in the Colorado case. It can rewrite the question presented very fast. So, and I have a lot of institutional respect for the Supreme Court. I was there this morning arguing a different case with my team. But, this is a little bit troubling. The best, I think, point I can come up with is Donald Trump did something last week which might have put some fuel on the fire of the Supreme Court hearing this case, which is he directed his lawyers in the Mar-a-Lago stolen documents case to file another bogus absolute immunity claim there. And what that might have done is say to the Supreme Court, look, this decision that we're being asked to review is from Washington, D.C. And yes, it's our nation's second highest court, but it only governs Washington, D.C. Florida and the Court of Appeals there might come to a different result, and we could have some conflict on this big legal issue. And so therefore, we, the Supreme Court, should hear this issue to set a rule for the entire nation. That's the best I can come up with for why the timing is what it is. But I am very concerned that the court has set an April 22nd hearing date here. They could have moved more quickly. I was a junior lawyer in Bush versus Gore. That whole case went to the Supreme Court on 2 different times, all within a 36-day period, briefing, decisions, everything.
Neil, I just want to go back to that point because I was thinking about exactly that today. And you and others raised it when Donald Trump raised that immunity defense in Florida. Instantly, lawyers started saying, this means the Supreme Court is probably going to have to take it because the District Court of Appeals in Washington, D.C. is not going to be a controlling opinion for the 11th Circuit down there where that case is. And so there's a certain logic to that. My question about that is, that could be an issue that Ketanji Brown Jackson wants to handle. That's one of the areas where it seems to me there's a wide range of members of the court who might say, if he's raising this immunity in 2 different jurisdictions, we just have to take it.
Yeah, I agree with that. I guess the thing I'd say on the other side, though, is why set it for an April 22nd argument? That just, why take so long? You can move
and Neil,
more quickly.
Is that completely up to the Chief Justice, the scheduling?
Generally, I think as a matter of practice it is, but I don't think he'd do something without the support of his colleagues. I think maybe the best thing we can hope for is that the chief and other justices feel like, look, there is still a lot of room in the joints, that we can decide this case quickly, and that there's two other actors here that could truncate their calendars. Judge Chutkan has said, look, I'm going to give Donald Trump 88 days from the time the immunity case is decided to the actual start of trial. But she said that well before the Supreme Court agreed to hear the case. And now Trump's got many more months to prepare for trial. So it's one thing. And the other is Jack Smith said this trial may take 2 to 3 months, but he has lots of options available to truncate the trial and make it go more quickly. So it's still very possible that the court could hear this case and still have Donald Trump tried before the election, but the math is a bit more difficult now.
Neil Katyal, I cannot thank you enough for extending your workday all the way past 10 p.m. to join us on this important night.
Thank you.
Thanks, Neil. And coming up, Harvard constitutional law professor Laurence Tribe will join our discussion next. And joining our discussion now is Professor Laurence Tribe, who has taught constitutional law at Harvard Law School for 5 decades. Professor Tribe, so glad to have you here tonight on this important night. What is your reaction to the Supreme Court deciding to hear this case?
Well, I was quite convinced, given how long they were taking, that they were likely to decide to hear it. What I didn't know, and what is very disappointing, is that they would formulate the question presented at a level of enormous abstraction so that the delay that we've already seen may just be the beginning. That is, the question presented is now whether and to what extent does a president have immunity after he leaves office from criminal prosecution for conduct alleged to involve official acts during his tenure. Well, of course, Donald Trump alleges that everything was an official act. Jack Smith is at the opposite end. Instead of that, if they really had any interest in expedition, any interest in satisfying the public need to get this trial going and to have a verdict one way or the other before the election, they would have asked a narrower question. They would have simply asked whether a president charged with criminally seeking to remain in office beyond the end of his term has absolute immunity from prosecution for crimes committed in that vein. That would have been the right question to ask, and it could only have had one answer. This question is so sweeping that there are a lot of ways of answering it. Yes, the president might have some degree of immunity for some official acts, but that is not the real issue. John Roberts long ago said that if a case doesn't require you to address a particular question, then as a federal judicial official, you shouldn't answer that question. You shouldn't reach out. By reaching out in this way, the court has guaranteed not only that there would be this bizarre delay, they could have taken this issue before them back in last December, not only that there'd be that delay, but now the delay until late April before hearing the case. There's no reason to have that several-month delay. In the Bush v. Gore case, everything moved 10 times as fast. This is a much simpler matter. It could have been resolved quite quickly. And the really weird thing is that essentially everyone knows where the story has to end. It cannot be the case that when a president is in office and tries to remain in office after losing an election and commits the crimes that are involved in that he is forever immune from prosecution. Yet that is what would have to happen to give this president immunity. So since we know that that's where the story has to end, to drag it out this way and have a virtual guarantee that the court won't decide anything until late June, it might decide this broad legal question and send the case back to the D.C. Circuit. Even if it doesn't No trial is likely to begin before October. In any event, no verdict of either kind, acquit or convict, is likely to happen before the election. And as a result, the people of the United States are confronted with basically a Supreme Court that is suppressing evidence that they need in order to decide intelligently whether the person they are voting for is guilty of the extreme felony of trying to steal an election and remain in office. That's an unconscionable way to proceed, and yet that's what the Supreme Court has arranged by the way it's organized this case.
So you're focusing on the exact words of the question, and the Supreme Court gives the lawyers the question they want them to address. You're focusing on this, the part where it says alleged to involve prosecution for conduct alleged to involve official acts during his tenure in office. That seems, the way you're reading it, to open the Supreme Court to arguments about each particular bit of evidence in the case. Was it an official act when President Donald Trump was asking Vice President Mike Pence to change the electoral vote count? Was it an official act when he was calling the Secretary of State of Georgia? Is that where the Supreme Court could end up here, evaluating each action described in the indictment?
Or laying out a blueprint and sending the case back to the Court of Appeals to evaluate the allegations, so that this is a formula for indefinite delay. I'm focusing also on the fact that the court asks whether, and if so, to what extent is there immunity? The question of whether the immunity is absolute or reaches only to a certain extent is a complicated question, the only complicated question in this case. It's the only one that the D.C. Circuit punted on, and it may be the one that the U.S. Supreme Court focuses on, namely, what is the contour of the president's official duties? What kinds of official duties are immune from criminal prosecution? It's an sort of open season for legal scholars, legal philosophers, not the kind of thing that a court that is supposed to be deciding the case before it ought to decide. This is a way of making it a much more complicated case, where the bottom line at the very end of all this backing and forthing is fairly clear, quite evident. The president can't have the absolute immunity to steal an election by obstructing the proceedings of Congress up to and including fomenting violence. That can't be immune from prosecution. Yet that is exactly what Jack Smith says he has the power to prosecute. So there's plenty of fault to go around here. Merrick Garland waited too long before appointing a special counsel. The special counsel proceeded with all deliberate speed, but even he could have gone a bit faster. This indictment could have been brought somewhat earlier. The case could have been narrowed. Perhaps it will be after the Supreme Court has its say. But if Donald Trump is reelected, the case goes away. So that even if we all agree that presidents can't be kings, they can't be above the law, after they leave, they're just citizens. Even if we all agree with that, in every practical sense, this president will have ended up being above the law, because he will have managed to use the procedural gimmicks and gears of the legal system to avoid being held accountable before he could again assume office and make the whole trial go away. It's not the way a country that is concerned to preserve the rule of law and constitutional democracy would proceed. And I think the court bears some real responsibility for proceeding the way it has.
The Trump lawyers made two arguments to get to the Supreme Court. One was the double jeopardy argument that you can't prosecute him now because he was impeached and tried in the Senate for the same charges. The court apparently has just thrown that out. They don't want that addressed at all. So that they've seemed to have already just dismissed. But the other part of it, the way the Trump lawyers phrased it was, are these charges, the things he's accused of, do they fall within his official duties or what they called within the perimeter, within the outer perimeter of the official acts of a president. And it seems to me that trying to define where the outer perimeter is, what that means in a case like this would be not easy.
Not easy at all, and not necessary to resolve the actual case before the court. Wherever the outer perimeter is, certainly the attempt to get the vice president to essentially name him the next president by tossing the election into the House, where we know that the majority of the delegations were controlled by the Republicans, trying to get the vice president to do that. And then when he refused to do it, fomenting a violent mob to cause delay, those things cannot be immune from prosecution, or else we have a formula for any sitting president to essentially stay in office permanently by killing his opponent or by killing senators in an impeachment trial. The range of possibilities is mind-boggling, and there's no reason for the court to have opened up that Pandora's box, except a desire to delay on behalf of Donald Trump. And that is obviously not a legitimate reason to proceed the way the court did.
Harvard constitutional law professor Laurence Tribe, thank you very much for joining us on this important night.
Thank you, Lawrence.
Thank you. And coming up, why hasn't Clarence Thomas announced his recusal from this case? Clarence Thomas's wife was a witness to some of the things Donald Trump did that are described in Jack Smith's indictment of Donald Trump. Congressman Dan Goldman has called on Justice Thomas to recuse himself. Congressman Goldman joins us next. In 1974, when Richard Nixon's presidency hung in the balance, the United States Supreme Court decided that Richard Nixon must turn over tape recordings of his conversations in the Oval Office to criminal investigators. Richard Nixon knew that those tape recordings contained evidence, indeed proof beyond a reasonable doubt, of crimes committed by Richard Nixon. Richard Nixon also knew that 4 of the 9 justices on the Supreme Court who were deciding his fate were appointed by Richard Nixon. One of those justices, William Rehnquist, recused from the Nixon case because he had served in the Nixon administration with some of the officials who were complicit in Nixon's crimes. The Supreme Court decision in that case was 8-0, ordering Richard Nixon to turn over his tapes. Justice Clarence Thomas lives with a woman who was complicit in the crimes White House Chief of Staff Mark Meadows is now accused of and the crimes Donald Trump is now accused of. Justice Thomas's wife urged them on in written text messages, urged them on in committing those crimes that they are now accused of and doing anything they possibly could, illegally if necessary, to overthrow the results of the presidential election. Will Clarence Thomas follow William Rehnquist's example and recuse from this case? Joining our discussion now is Democratic Congressman Daniel Goldman of New York. Congressman Goldman, I know you have, in effect, demanded Clarence Thomas's recusal, but he doesn't seem to follow any of the precedents on this kind of issue that we've seen from other justices.
No, and I think we have our answer. If he were to recuse, we would have seen it in today's order, and he's not. And it is absolutely baffling, Lawrence, not just because of the precedent of Chief Justice Rehnquist or then Justice Rehnquist that you point out, but the fact that his wife was involved in the conduct that underlies the criminal charges against Donald Trump, about which he is seeking immunity from the Supreme Court, and Clarence Thomas has not recused himself, is perhaps the greatest ethical lapse that we've seen in a Supreme Court justice. And under the new guise of impeachment that this House Republican majority has created with the impeachment of Secretary Mayorkas, if the Democrats win the House next year, I think we are going to have to think about what our actions are in terms of reining in this rogue Supreme Court, bringing judicial reform and ethics back to the court so that its credibility is restored, and even up into and including the possible impeachment of Clarence Thomas because he continues to flout basic common sense rules of ethics for any judge, much less a Supreme Court justice.
Clarence Thomas's wife was with Donald Trump, was in his presence when he committed some of the acts that are considered part of the criminal conspiracy in the case that the Supreme Court's going to consider. She was there when Donald Trump was giving his speech to his followers, telling them to go to the Capitol and fight like hell. She was there clapping for that. Just like all the Trump followers were. She, like Donald Trump, didn't go to the Capitol, but she was there when he urged him on. And here's Clarence Thomas considering a case that includes that evidence about his wife.
As well as text messages where she is urging Mark Meadows, the president's chief of staff, to do whatever he possibly can to keep Donald Trump in office, which is exactly what he is charged with criminally doing by using false and fraudulent means in order to maintain his position as the president of the United States and interfere with an election. It is I don't know the evidence here, Lawrence, but this would be somebody that, as a former prosecutor, I would consider referring to as an unindicted co-conspirator, which means that there is some complicity. There are some actions that link such a person to the crime that is being charged. And the notion that Clarence Thomas would rule on a case where his wife may be an unindicted co-conspirator is perhaps the greatest ethical lapse that we've seen. And lapse is not even the right word. It is a true flouting of the code of ethics, of the rules of ethics, of basic common sense ethical guidelines. And the Supreme Court has demonstrated that it cannot police itself. Congress must enact, and Republicans must get on board with enacting some sort of judicial reform so there is a code of ethical conduct that applies to Supreme Court justices as it does to all other federal judges. But this is a true crisis of credibility at the Supreme Court right now.
And it is just stunning to compare to the Rehnquist standard. It wasn't anyone in Rehnquist's family. It wasn't Rehnquist's wife. That's not why he was recusing. He was recusing because he had once worked for Attorney General John Mitchell, who looked like he was in the line of culpability in the Nixon conspiracy, and indeed was. John Mitchell, first Attorney General in history to be convicted of a crime, sentenced to prison. And Justice Rehnquist wanted to be nowhere close to that. And Clarence Thomas is so much closer to what this case is about.
He's so much closer, and he has now demonstrated a pattern of ethical, financial disclosure issues and problems and lapses that have been documented in quite great detail by excellent investigative reporting over the past couple of years, where he is clearly using his position for his own financial benefit. And now he is using his position to potentially protect his wife from criminal conduct. It is shocking when you actually just say the words that a Supreme Court justice has not recused himself from a case in which his wife may be an unindicted co-conspirator. I'm not a constitutional or Supreme Court historian, but I certainly do not know of a situation like this.
Congressman Daniel Goldman, thank you very much for joining our discussion tonight.
Thank you.
Thank you. Coming up, despite today's action at the Supreme Court, criminal defendant Donald Trump is going to trial in his first criminal trial, which will be in Manhattan just 3 weeks from now. Nothing the Supreme Court did today changes that. And Donald Trump is now struggling under the weight of $500 million in civil judgments against him in New York, which he told a court today he cannot afford to pay. The appeals court refused to give Donald Trump more time to find the money. That's next. Donald Trump's first criminal trial is now less than a month away in Manhattan, where Donald Trump will face charges of tampering with the 2016 presidential election by hiding from voters the truth about his relationship with porn star Stormy Daniels while he was campaigning for president by delivering hush money payments to her. District Attorney Alvin Bragg charged Donald Trump with business fraud for trying to cover up the hush money payments that he gave to porn star Stormy Daniels to hide their relationship so voters would not know about their relationship in 2016. That case is still going to trial, and there is nothing today's decision by the Supreme Court can do about that. Also in New York today, Donald Trump said under oath that he does not have enough money to cover the civil judgments against him after saying under oath earlier that he does have enough money. Today, a New York appeals court refused to delay Donald Trump's obligation to pay that judgment or put up the money to the court for that judgment so that he can then appeal that civil fraud judgment against him in New York, which is, as of tonight, $464 million. Joining our discussion now, Joyce Vance, former federal prosecutor and a professor at the University of Alabama Law School. Also with us, Tim O'Brien, senior executive editor for Bloomberg Opinion and author of Trump Nation. They're both MSNBC analysts. And Joyce, I want to begin with the Manhattan criminal trial, which remains very much on track and is now, without a doubt, the very first criminal case that will be going to trial against Donald Trump. And in a way, it's an extension of what we've already seen in the civil fraud trial. But this is a criminal business fraud that he's charged with to cover up the payments to Stormy Daniels.
You know, it is a criminal business fraud, Lawrence, but I view it more as akin to an election interference case. This is Donald Trump's origin story. This is his first election for president. And what's happening, the Access Hollywood tape is released. He's concerned about how women voters are viewing him. And so he tries to keep evidence of his payments, or he tries to keep evidence of his relationship with Stormy Daniels out of the hands of voters as they're preparing to go to the polls. And he does that, in essence, by cooking the books at his business. But this is a lot more than a business fraud case. This is really about election interference.
And Tim O'Brien, I don't see any way Donald Trump could take the witness stand in a case like this where he would be open to questions under oath in a criminal proceeding about how he handles his business records.
No, I mean, he's an attorney's worst nightmare on the witness stand, Lawrence. He bloviates, he lies, he tries to joust with his interlocutors. He's not disciplined. I can't imagine they'd want to have him on a stand where he would just sit there like Yosemite Sam shooting himself in his own feet. And I wouldn't expect to see that at all happen.
So, Joyce, Donald Trump, under oath in a pretrial deposition, said he has at least $400 million in cash. Now, when he needs that in order to proceed with an appeal, he needs to post the amount of money that's involved in the case, in the judgment of the case, in order to appeal, suddenly saying, gee, I can't afford it. I just don't have that much money. What happens next?
Yeah, so look, you know, the whole point here is Donald Trump can appeal this judgment. He has a right to do that. The question is what happens while he's taking the appeal. Can the New York Attorney General go ahead and try to collect her $464 million in growing judgment against him? And the answer is that if he doesn't post a bond or pay the full amount into the court fund, that she can begin to collect against him. She's already indicated she has her eye on a couple of Trump properties in New York. So presumably he's out beating the bushes and talking to lenders of last resort, trying to get a bond in place by the March 25 deadline. But if he can't come up with it, if he really is, in his own words from this motion today, if he really is struggling financially, then we could have the specter of him facing a criminal trial in Manhattan while Tish James begins to execute and try to collect her judgment against him at the same time.
And Tim, might that be Donald Trump's play in the end? Just can't put up the bond. Therefore, let Tish James try to take one of these buildings and auction it off, knowing that can be a long process, that he can have various ways to fight legally along the way.
Perhaps, but that's a crazy gambit because he ultimately will lose control of those properties. One of the things we're seeing in this case, as it always is with Donald Trump, is there's now a public referendum on his wealth. And he spent, 55 or so of his 78 years lying or bloviating about how much money he has. And now when push comes to shove, a man who has routinely said he's a multi-billionaire is having trouble scrounging up several $100 million to make good on a court judgment. As one, veteran New Yorker once said of Trump, I wouldn't believe anything coming out of his mouth, even if his tongue was notarized. And so all of his, proclamations that he had several $100 million in cash on hand don't appear to be true. That means he then has to go to hard property and try to sell it. And that's complex. For example, two of his most valuable buildings, one that's in New York and one that's in San Francisco, he's the minority partner in those buildings. A major real estate firm owns most of those properties. He is not going to be free just to sell out his stake without his partner allowing him to. And everybody in New York real estate or anywhere else he has a property now knows he's going to be selling under duress if he has to. And he's not going to get a good price for some of these properties. And he's arrived in this place because he and his lawyers decided very early on to try to beat up the judge in this case. And the judge came down with a very hard penalty, and Trump's in a corner.
And of course, Joyce Vance, the New York Attorney General's office has specialists in the office who know how to do exactly this, how to pursue assets like this and seize them from defendants like Donald Trump.
She does, and I'd be stunned if she hasn't been making book on him from day one, trying to figure out precisely how she would collect this judgment. It's great to get a judgment, but when it's really meaningful is when you're able to return the money that's being disgorged from a fraudulent business like this to taxpayers. And she has made it clear, even with her tweets where she's been totaling up the daily additional increments of interest, that she is very focused on the collection phase of this litigation.
Tim, quickly before we go, what do those tweets do to Donald Trump? Every day, the New York Attorney General issues a new tweet, and it's just the number. It's just this is how much money he owes today. This is how much interest went up today.
I imagine that feels like a hot needle being drilled into his brain every time he hears the number or someone tells him about it, because it's an indignity. Again, it's a reminder that a man who had this myth spun around him about evading the long arm of the law now has been pulled in tightly into its grasp, and there's a big dollar sign attached to that. And she's making hay off that every time she tweets.
Tim O'Brien and Joyce Vance, thank you very much for joining us tonight. Thank you.
Thanks, Lawrence.